Oh, hello. Back to our chapter overviews or our reading overviews. I'm looking at the end of, or I'm looking at the week 1 agenda. When you get to the end, we always talk about our assignments for the following week, right? So you'll find this in our learning plan too, because it will help you with all the work you're going to do for that. So this wants us to look at pages 13 through 22 in chapters 1 and 2. So again, I'll be doing these all in one since there's not too much to cover. So on page 13, it starts that section 1 overview about safe hiring practices. So that's what this first section is about. And it gives you basically the history of why a lot of this exists in the first place. So for example, on the bottom of page 13, prejudice. If we hadn't had cases involving prejudice and discrimination, we wouldn't necessarily need all of this, right? So on page 14, they talk about both ignorance and prejudice, and you can see the result of some of this when you look lower in the page, the 7 laws and executive orders, that have been created as a result. And of course, this is the short list, the very short list, right? That's why we're not going to memorize this kind of stuff. But the Civil Rights Law of 1866, going back as far as 1866, Title VII of the Civil Rights Act, 1964, all of these things give us an idea of, as they've come along, we're like, well, I guess we're having problems with age, so age discrimination. Then on page 15, how civil rights legislation helps you manage effectively. If instead of looking at all of this as like punishing the employer, maybe just look at it like the title on this book. Fair, square, and legal, right? So to do things fairly, not just legally, but for me to do things fairly, it really helps us if we have a guide, like these definition of key terms. A protected class. What is a protected class? A bona fide occupational qualification. If you understand what these things mean and discrimination, then you maybe won't do things that violate those and you won't get into trouble, right? So fair, I think, is a much better word than just being legal, okay? You can read what you cannot do. So I love this book, what you can't do and what you can do. But on page 17 gives you an idea of the consequences of intentional discrimination. Now, that's why I'm somewhere along the line here, you're going to have an assignment where I'm asking you to take a look at words like malice, like with malice, intent. Those are the kinds of things the judge looks at. It's like, well, consequences of intentional discrimination. So you did it intentionally, and which was with malice, right? So a court order stopping the company from conducting unlawful employment practices, court action to force an organization to comply if it's necessary, reasonable attorney fees and other costs. This can be very costly if you're doing something and you probably should know better and you get caught, right? What's the old saying? It's not illegal till you get caught. Ooh, that can be very painful. Oh, on page 18, also, ignorance of the law is no excuse. That's another old phrase, right? On page 18, falling behind a shield of good intentions may not be a sufficient defense. It will not be a defense at all. Again, that is ignorance of the law. Not acceptable. Tells you what you can do, which is usually, of course, the opposite. One thing I do want you to understand is, again, it's not as, oh, there's nothing we can do, right, kind of attitude. On page 19, talking about ensuring that pay distinctions are not pretextual or result of deliberate discrimination. For example, paying women less for the same work, right? Or anybody else for that matter. But you can pay people differently based on legitimate, legally accepted practices, like, for example, seniority, merit systems, piecework, commissions, or even according to location. So there's different ways you can set up your compensation packages. They just have to be fair and legal, right? It does mention the use of pre-employment testing. Excuse me. So you need to avoid pre-employment testing unless it's requires a requirement to do the job. So if you have a job where you have to do basic math, then saying that you have to take a math test is perfectly legitimate, as long as it's maybe not advanced math, if that's not what's necessary, right? You guys can read the rest of that. Oh, one really good point on page 21. Two things. On the top of page 21, it carries over: to be legally acceptable, a system must be based on objective considerations or standards and cannot be used so as to produce either disparage treatment or adverse impact. Two very key phrases: disparate treatment and adverse impact. These are the kinds of the things that make us not want to give job references. So for example, someone calls and says, so-and-so says they worked at your place of employment from, A to B, whatever. And you say, well, yes, I can confirm that. And then then people don't tell anybody, say, oh, we're going to get sued if I say anything bad. No, you're only going to get sued if you say something bad, if it causes disparate treatment, meaning that if it harms the person you're talking about, defames, slanders, or whatever, if it's not true. So you have to be very, very careful. There are things you can legally talk about, but there are things that you just shouldn't talk about. But it doesn't mean you don't say anything. And I don't know if it's in our HR class or this class, we actually go through some criteria that will help you with that. Adverse impact, same kind of thing. If it's going to cause adverse impact based on something you've said that you shouldn't, then you can be called on the carpet for that, right? But that's not everything. There are ways that we can talk about people's, as long as it applies to the job, right? One key thing you'll often hear people say is, well, if you were able to hire them again, would you? And it's kind of like HR code. If you say no, there's some issues you don't want to talk about, but you wouldn't hire them again. If you say yes, then that's a whole different story, right? Then at the bottom of page 21, another good point. Legal procedures or rules of evidence may change, but one principle underlies all equal opportunity laws: to protect people who have, for one reason or another, been denied equal opportunity in the marketplace. Okay, that's why knowing with this book, I think this 2004 was when it was updated last. Partly why we still keep it is because these principles don't really change that much. Now, some of the laws and the practices and the executive orders and that kind of stuff might be updated or changed or added as new things are learned, like bullying in the workplace. We have new legislation, not every state, but Wisconsin is one. That that will change, but the principles behind all of this don't. Now, chapter 1, starting on page 23, safe recruiting practices. So you're bound by this level of fairness even before you hire. This starts with even the ad that you run in the paper, the want ad for help wanted, or whatever you want to call it, or online, or whatever it is. This begins even before you've hired anybody, before you've even met them, right? So you have to be very careful. It tells you here what you cannot say, unless it is a special, the bona fide occupational qualification. That means that it's required to do the job. So, for example, like one of the classic examples, if you are advertising for a woman to model women's lingerie, you can say that, versus no men allowed kind of thing. But if it's for something very specific, age limits, special age limits, for example, it better have a reason. Another classic example are pilots. I remember my husband used to be a private pilot. He hasn't kept up with his license now, but I think when he was licensed, by the age of 55, I think they might have upped that now. At the age of 55 or so, I mean, you might have been looking for another job because you felt you were just too old to safely fly planes or something or other. All the other stuff is pretty straightforward. Page 25. Even though very few people go to court because of the way an advertise is written, someone could use your ads as evidence when suing you for discrimination in some other way. So they aren't necessarily taking you to court for the ad itself. This is why I love the law. It's so interesting because there's always like 101 ways to look at it. So if you sue for the wrong thing, you can often lose. If you're trying to sue for the way the ad was written, you're probably going to lose. But if you're using the ad and suing them for discrimination because it supports your thesis, that one you might win, right? So the example in the casebook at the end of the chapter will help illustrate that. So you can read those cases, like I've said, at the end of the chapter and give you a pretty good idea about that. It tells you what you can say, talking about, and a lot of this is kind of HR stuff. So you can read through this and talk about what a job profile is. These are the kinds of things that should help you write a really good, fair, legal ad that not only covers those bases, but also gets you the right candidate. We really are trying to tap into the right person for the job. Oh, they give you some samples here, a sample safe job description, a sample recruiting guide. On page 31, it starts talking about electronic recruiting, and you guys are going to do an assignment about e-recruiting. I thought this was so interesting because we just haven't kept up with technology. Our laws just haven't kept up with technology, and this is a super good example of that. It says companies in ever-changing numbers have turned to the internet to recruit employees. Now, this was updated in 2004. It's 2018. Oh, good Lord, right? Some of them now accept only online resumes. This often conflicts with the EEOC's requirement that companies with more than 100 employees file resumes for 1 year and log in demographic data to include gender, race, blah, blah, blah. Now, since more than 52 million Americans at this writing have searched for a job via the internet, critics complained that this requirement places an overwhelming burden on the company and their resources. So that's what I mean about some of these things. When this was written, they were way behind because it was just escalating so fast with technology, just changed everything so exponentially quick, right? But the premise of this doesn't change, though. And then they talk about on page 32, on the other hand, many companies have developed specialized software. And early on, there were lawsuits and they mention it here, those keywords tend to respond to words that were written only by whites, not African Americans. And there was a test case in 2001 that failed to reach a court-mandated conclusion when the company settled with the applicants out of court. I believe Disney might have been, I don't think that's the case they're referencing here, but Disney was part of this too. They were early adopters of online recruiting, unknowingly that, the average person that's writing the software were younger white males, right? That's the average. Well, the vernacular, the words that they use to develop the software, right? The key words, like they're referring to here, key words that the software is picking out, because they were written by younger white males, if you weren't a younger white male and didn't have necessarily the same vernacular, didn't speak in the same way, now that can be even just by region in the United States with a Southern accent, for example, and some of the terminology that they use versus if someone, what Silicon Valley, West Coast, Northern West Coast, right? It would boot those out. And as it turns out, there was disparaged treatment unknowingly, but it wasn't intentional by the company. It was just that there was all new technology, and we're much better at doing it now, but still it's a concern. And then there's another assignment that's going to ask you a little bit more about that. What are some of your concerns today when it comes to e-recruiting? You guys can read the case study. Then if we look at safe interviewing practices, chapter 2, page 35. Now, of course, we've done the recruiting, we've got some people in, and we want to do the interviewing. What you cannot do. Now, I've already got an exercise for you that you're going to be doing, like what can you ask and what should you or shouldn't you ask. And this will help you with that. So I'm not going to read through that. I don't want to give it away. You guys can take a look at that. Safe questioning. You can read that. That will help you with that little assignment. It's just not an assignment. It's part of one of our class activities. And then next week I'll give you some feedback on that, what the answers are. And then, of course, there again is just the case study, or excuse me, the cases at the end of the chapter. And again, they offer us an example, an application for employment on page 45. So if you are interested or are working in HR, there are some samples in here that are pretty universal. There's so much stuff out there on the internet. There's so many resources for HR now that there's really no excuse for not learning how to do this well. So that wraps up our reading that will help you do the work for week 2. And then I'll see you in the next one. Bye.